everyone, welcome to another episode of Legal Reform with Jess. So today I'm going to be talking about the phenomenon of revenge porn, and I'm going to be discussing the different ways and the extent to which the Commonwealth and New South Wales laws currently deal with those who distribute and share private material non-consensually. In today's episode I'll be pointing out that the current laws addressing this growing phenomenon are inadequate and are patchy at best. So for all my budding legal eagles and YouTube followers, it may come as a shock to you that the current New South Wales and Commonwealth criminal provisions actually fail to directly address revenge porn offences. So due to this shortcoming, it's pretty obvious that the Australian people are in dire need of a federal offence and a New South Wales offence that specifically deals with this heinous crime. In today's vlog, I'll be considering the New South Wales government's approach to this issue, which, in case you missed it, the New South Wales government are proposing that a new criminal offence specifically addressing revenge porn be introduced. As per usual, I'll give you all the lowdown about it and give you my opinions about this proposed new offence. In this episode, I'll also be talking about a federal bill that was actually passed to specifically address the private sharing of sexual material. Unfortunately, the bill didn't proceed due to the fact that it lapsed at prorogation. Nevertheless, I think it's still important that Parliament consider bringing this bill back, and again, I'll be looking at the virtues and the shortcomings of this legislation. Anyways, it's time to get this show on the road, so let's get started off with the basics. Revenge porn, or as the New South Wales Senate prefers to call it, the non-consensual sharing of intimate images, occurs when a person has an intimate or sexually explicit image or video of themselves posted online, or this content is distributed or shown to others by another person without the victim's consent. So for example, these images may be obtained in an intimate relationship, they can be photos or videos of a sexual assault, and may be images stolen from a person's personal device such as a computer, mobile phone, tablet, etc., or it can even be stolen from a cloud account. These actions have typically been deemed revenge porn due to the fact that many of these breaches of privacy have occurred during a relationship or after the breakdown of a relationship, with ex-partners uploading or distributing this intimate and private content for others to see. The scary thing is that this is a growing phenomenon. You just have to look at the very public case and incident involving Australian model Lara Bingle, in which a photograph was taken of her in the shower by footballer Brendan Favola, with whom she was having an intimate relationship with, and this photo was shared by Mr. Favola without her consent. Not only are there more and more instances of these violations of privacy occurring each day, but there are websites dedicated to this revenge porn material. According to the New South Wales Parliamentary Research Service, it's been reported that there are at least 3,000 websites dedicated to the revenge genre. Pretty shocking, right? Moreover, there are a whole slew of other ways that non-consensual sharing and distributing can occur. For example, it can be sent on by text, message or email to family, friends, colleagues, employees and strangers. They can be uploaded onto social media sites like Facebook, Twitter, Instagram, Tumblr and Snapchat, or even to online communities and threads like Flickr and Reddit. It can also be distributed the old-fashioned way, physically by hand in public spaces or even by sending by post. What's particularly horrific about this crime is that it's extremely commonplace in Australia. Research conducted by Drs. Nicola Henry, Dr. Anastasia Powell and Dr. Asher Flynn indicate that 1 in 10 Australians aged between 18 and 55 years old have had a nude or semi-nude image of them sent to others without their permission. Just let those scary stats sink in. It should also be noted that such intimate material may be shared and distributed for a range of other purposes other than revenge. For example, it may be used to coerce, blackmail, humiliate or embarrass the victim, or it may be done for sexual gratification, for fun, for social notoriety, or even to gain a financial benefit. People should be free to take intimate and sexually explicit images or videos without fear of this content being passed on non-consensually. Moreover, revenge porn can be extremely devastating for its victims. Not only can it lead to severe consequences, including psychological damage to the victim's current and future relationships and to their careers, but it can even lead to further abuse by others and sometimes even suicide. What is most frustrating about this is that it's clear that revenge porn is such a serious epidemic in our society, and yet the state and federal government has failed to provide victims with adequate recourse through legal mechanisms. This all needs to change. Let's start off with the New South Wales offence. In New South Wales, Section 578C subsection 2 of the Crimes Act 1900 New South Wales states that a person who publishes an indecent article is guilty of an offence. This provision was most notably and successfully used in the 2012 revenge porn case of Usmanov and Regina, where the defendant posted 6 intimate photos of his former partner to Facebook without her consent. However, when looking at the Section 578C provision, some may find it odd that it's been used to prosecute crimes for the non-consensual sharing of intimate images. Firstly, the provision is worded as follows. A person who publishes an indecent article is guilty of an offence. So what exactly do the phrases publish, indecent and article cover? Firstly, an article has been defined in subsection 1 as to include anything that A, contains or embodies matter to be read or looked at, or B, that is to be looked at, or C, a record which can include a tape or film on which sound or pictures are recorded or can be produced. Due to the fact that the term contains or embodies matter to be read or looked at is extremely broad, the prosecution have frequently used it to cover different types of revenge porn cases. And so Section 578C is able to be used, for example, when intimate photos are non-consensually taken and uploaded to Facebook or Twitter, etc. Moreover, subsection C covers the realm of intimate films that have been published non-consensually. However, what's interesting is that intimate phone calls or sound bites that may have been recorded are not covered by this provision, which can be troubling. Whilst the definition for publishing for this section is extremely broad and includes, for example, disseminating, distributing, circulating, exhibiting, exchanging, selling and offering for sale, or having these materials in possession or custody or under your control for the purpose of publishing, and even printing the photographs for the purpose of publishing, what is curious is that this provision fails to include situations where a perpetrator may be non-consensually showing a third party an intimate image on a computer screen, for example. What you may have noticed is that the phrasing of Section 578C does not in any way directly address revenge porn. Ultimately, it's simply used since there is a clear absence of a more suitable offence currently in place. There are also several other major problems with this current provision. For example, problem number 1. There's nothing specific about motive, intent or consent in this provision, which is extremely important when considering cases involving the non-consensual sharing of intimate images. For example, even if the victim consented to have their intimate images shared in particular ways, the perpetrator would still be subject to the Section 578C offence. This is extremely odd given that consent by the victim should be a defence in revenge porn cases. Subsequently, it's important that the issue of consent is addressed when drafting the legislation for any future offences dealing with revenge porn. Problem number 2. As I mentioned earlier, Section 578C is an extremely broad provision. Nevertheless, the provision fails to consider the different methods and technologies that may be used in the dissemination of intimate images non-consensually, which is particularly fatal given that the majority of revenge porn cases involve the use of sharing and distribution via technology. Moreover, it can be argued that due to the fact that this provision is so broad, the police have greater discretion as to what they can charge. Problem number 3. This section focuses on the publishing of indecent articles. However, the use of the phrase indecent is particularly troubling. The wording of this provision ultimately deems intimate photos, videos and content as indecent, thus encouraging a form of victim blaming. Essentially, this provision implies that the victim was in the wrong for creating this indecent material, and this takes away the focus from the wrongful actions of the perpetrator. Problem number 4. To date, this provision has not been widely used in cases involving the non-consensual sharing of intimate images. Due to the fact that it's only really been used successfully in the Usmanov case, there's been a lack of clear precedent discussing how this section can apply. Although criminal offences dealing with stalking, blackmailing or voyeurism offences in New South Wales exist, these are not appropriate when dealing with revenge porn cases. Moreover, given the fact that Section 578C is the only section that can broadly deal with the offence of the non-consensual sharing of intimate images, it's clear that New South Wales does not have a comprehensive body of law that effectively deals with this growing phenomenon. Section 474.17 of the Commonwealth Criminal Code Act 1995 states that using a carriage service in a way that reasonable persons would regard as being in all the circumstances menacing, harassing or offensive constitutes an offence. Again, it must be noted that this offence is not specifically targeted to the non-consensual sharing of intimate images. Rather, such behaviour may fall under the scope of this offence. On the one hand, Section 474.17 addresses the fact that technology, and specifically carriage services, may be used to engage in menacing, harassing or offensive conduct, such as that demonstrated in revenge porn cases. However, it must be noted that perpetrators often engage in such behaviour using anonymous usernames or pseudonyms, and thus it may be difficult to uncover the identity of the individual committing the crime. For example, in order to do so, the police would need to go through a massive task of going through the data retention logs from the internet service provider used to identify the specific perpetrator. Another interesting thing to note about Section 474.17 is that there's a requirement that reasonable persons be considered the standard for this offence. The problem with this requirement of reasonable persons is that different people might interpret menacing, harassing, or offensive behaviour in different ways. For example, some individuals may be more sensitive or more affected by such behaviour than others. This is particularly troublesome when applied to revenge porn cases, since it totally fails to consider the particular victim's circumstances or position. For example, revenge porn can be used by the perpetrator as a form of domestic abuse in order to control or coerce the victim into staying in a violent relationship. By making the standard that of reasonable persons, Section 474.17 fails to take into consideration that the victim is potentially more susceptible to consider the perpetrator's behaviour as menacing, harassing, or offensive due to the fact that they've been subject to long-term domestic abuse. Additionally, it can be argued that this reasonable person test may not necessarily address the humiliation, embarrassment, distress, or shame that a particular victim may feel as a result of the perpetrator's behaviour. Section 474.17 also fails to consider these particular issues, which are crucial in revenge porn cases. Number 1, it fails to consider whether the victim gave consent. Number 2, it doesn't consider whether the victim held and maintained an expectation of privacy in relation to the intimate material. Number 3, the legislation fails to define what may constitute offensive communication, particularly in the context of disseminating intimate, personal, or sexual material electronically. Number 4, again like the New South Wales offence, this section does not cover non-online conduct, such as distributing hard copies of the intimate material by the perpetrator. And number 5, it is unlikely that this section would cover a verbal threat made by the perpetrator that they would distribute intimate material of the victim online. It should also be pointed out that Section 474.17 has not been widely used in general. Since the commencement of the provision in 2005 until January 2014, there have only been 308 successful prosecutions under this section. Overall, I think it's pretty clear that this section fails to adequately address cases involving the non-consensual sharing of intimate images. So what should the government do to address such criminal behaviour? Obviously, they need to look at creating a new offence. In particular, I think that it's important to keep these following factors in mind when introducing this new offence. Factor 1. The new offence should be the crime of the non-consensual sharing of intimate images at both the Commonwealth and state levels in order to fill the gaps within the existing law. I'd also like to stress the importance that a new offence be introduced at the Commonwealth level in particular rather than just amongst the states. A Commonwealth law will provide consistency across all the territories and states, and they will assist in prosecuting perpetrators, for example, if they cross the physical borders within Australia. A new system like this would provide total coverage over revenge porn offences. Factor number 2. This new offence should be a statutory crime. Not only will a statutory crime reinforce how serious and wrong the perpetrator's actions are, but it may provide a wake-up call to the general public as to how damaging the sharing of non-consensual material is for victims. Importantly, it will have a symbolic function as it might help to deter people from engaging in such behaviour due to any penalties that may be incurred. So it actually seems that the New South Wales government have heard our cries and have proposed that they will introduce a new offence specifically dealing with revenge porn crimes in New South Wales. So right now I'm just going to give you guys a breakdown about the proposed new offence. Element number 1, the definition of an intimate image. The New South Wales government have actually recognised that any future legislation needs to clearly define the types of subject matter captured by this new proposed offence. In particular, the New South Wales Senate highlighted that the new legislation should deem the offensive conduct as the non-consensual sharing of intimate images or image-based exploitation rather than naming it revenge porn. Firstly, as I mentioned earlier, revenge may not necessarily be the perpetrator's only motive. Rather, engaging in such behaviour may be done for notoriety, financial gain, entertainment, etc. Therefore, it's preferable to use the phrase non-consensual sharing of intimate images, as such a term does not focus on the motive or an intention of the perpetrator. Secondly, describing intimate material as porn suggests that the victim has created pornographic material. Not only is this a form of victim blaming, but it takes away the focus from the offender's conduct. The legislation for the future offence also needs to clarify whether it covers material that is considered intimate, but is not necessarily sexual in nature. The new offence should include such material, given that what may be considered intimate or personal material may differ according to different cultural contexts. as the New South Wales Senate highlighted in their report addressing revenge porn, a photo of a Muslim woman not wearing her hijab may be considered intimate in the Muslim community. Moreover, sharing a photo that isn't necessarily sexual in nature may be just as harmful or cause distress to the victim. However, the scope of the new offence should not be so broad as to cover the sharing of material that is considered socially acceptable. So, for example, an image of two people kissing. Element number 2, the definition of distribution. The New South Wales Government also recognised that any legislation for the new offence needs to clearly define what distribution means. In particular, I think that the new offence should obviously cover intimate material distributed by technological means, so for example online via websites, social media services and cloud services, etc., as well as physically, such as sharing a hard copy version of the intimate material or showing such an image to a third party either on a computer screen or a phone screen. On the one hand, clearly defining the phrase distribute will help to specify what type of conduct falls under the scope of the new offence. However, on the flip side, it can be argued that the phrase distribute should not be so limited as to potentially restrict ways of sharing or distributing that may occur in the future, particularly considering that new technologies may provide for new means of sharing. Element number 3, should the new offence cover the taking or recording of an intimate image without consent? The New South Wales Government raised the question as to whether the new offence should not only include sharing but also the taking or recording of an intimate image without consent. Currently, Section 91K of the New South Wales Crimes Act 1900 provides that it's an offence to film a person engaged in a private act, and Section 91L states that filming a person's private parts is an offence. However, the major problems with these sections is that such filming must be done for the purpose of obtaining sexual arousal or sexual gratification. Therefore, they don't really cover revenge porn situations where filming of the victim may be done for a range of purposes such as either revenge, to humiliate, or to embarrass the victim, etc. Consequently, I think it's imperative that the new offence should cover the taking or recording of an intimate image without consent, as it's clear that the current law fails to take into account such behaviour. Element number 4, should the new offence cover the making of threats to share the intimate images? I believe that the new offence should cover behaviour where the perpetrator makes threats that they'll non-consensually share the intimate material. This is due to the fact that threats can be just as serious an effect on the victim as the actual distribution or sharing of such material. Moreover, the offence should apply irrespective of whether such intimate material actually exists. Making threats, whether done implicitly or explicitly, can be considered a form of control, coercion, and harassment, and even if these images don't actually exist, these threats are still harming the victim in some way. Element number 5, should the new offence cover photoshopped images? I believe that the new offence should also cover situations where the victim is photoshopped into an intimate image. So for example, where the victim's head is pasted onto a pornographic image and this edited photo is then distributed without the victim's consent. If such conduct is not covered by the new offence, it would potentially create a loophole for perpetrators to engage in such behaviour. Moreover, photoshopped images can be just as harmful to the victim as those that are actually real. Element number 6, the fault element for the new offence. In my opinion, I think that if a person non-consensually creates or distributes or makes a threat to distribute intimate images of the victim, whether they did so knowingly or recklessly, they should automatically be subject to the new offence. I think it's useless to consider whether the perpetrator showed that they intended to harm the victim by their actions, since in most cases the harm is already caused to the victim regardless. If the new offence did require that the offender intended to harm the victim, it would provide a legal loophole as the perpetrator could simply argue that they didn't intend to cause harm or distress since they engaged in the behaviour for other reasons. Additionally, having a standard of recklessness may help to address situations where it's difficult to prove whether or not the victim consented. Element number 7, consent given by the victim. The New South Wales Government also posed the question of how consent should be defined in the new offence. I believe that we should follow the suggestion given by the Office of the Director of Public Prosecutions in New South Wales, such that consent needs to be explicit and express, and would need to refer to that particular image at that particular time and in the particular manner used by the perpetrator. I believe that consent should be explicit and express, given that it may be extremely difficult to determine whether consent was impliedly given by the victim in certain situations. Additionally, the new offence should require that there be separate consent given by the victim for the creation of the image, as well as separate consent given for the distribution of the material. Furthermore, due to the fact that several revenge porn cases involve the distribution of an intimate image after a relationship has ended, the offence should take into consideration that consent terminates upon the breakdown of a relationship. Element number 8, potential penalties. The new offence should follow the penalty system in Section 26C of the Summary Offences Act 1953 in South Australia, which deals with the distribution of an invasive image. The South Australian provision states that offenders will be fined up to $10,000 or imprisoned for a maximum of 2 years for the offence involving the image of an adult. However, distributing an image of a minor will result in a maximum penalty of $20,000 or maximum imprisonment for 4 years. These penalties obviously appropriate as they specifically take into account that offences involving minors warrant more serious penalties. The new offence should also provide the court with the discretion to require an individual convicted of an offence to take down or remove the intimate material in question. Given that the content may be uploaded and shared on many different platforms, such an order may help to stop the further spreading of the content online, and it would also help to address the problem at its root. Moreover, if the perpetrator breaches this court order, they should be subject to a further offence. If there are no repercussions for failing to abide by the court order, it would carry very little weight. So in 2015, the Commonwealth Criminal Code Amendment Private Sexual Material Bill 2015 was introduced in the House of Representatives. This bill was designed to specifically respond to revenge porn. Unfortunately, the bill lapsed at prorogation. However, I'm still hopeful that Parliament will consider bringing this bill back to life, as it would provide blanket protection to victims across the country. Nevertheless, I think it's still useful to consider both the positives and negatives of the bill, just in case it is revived in the future. So the bill aimed to introduce 3 new telecommunication offences. The sharing of private sexual material of a person without their consent that would cause them distress or harm. Making a threat to another person to share private sexual material that they're depicted in, or another person that they care about is depicted in, or engaging in such behaviour for the purpose of obtaining a benefit. Section 474.24d dealt with the type of material that would be considered private sexual material. Firstly, the definition included content in which the person is engaged in or appears to be engaged in a sexual pose or sexual activity. One problem with this is that the bill fails to specify what may constitute as a sexual pose. So, for example, would the offence cover a situation if the victim was posing while wearing lingerie in the photo? Secondly, the definition covers a person photographed or filmed in a manner or context that is sexual. This fails to take into account that non-sexual images may be considered intimate in certain cultures. The bill also fails to specify whether the definition of private sexual material covers still or moving images, or whether it would also include private written communication, artwork, or voice recordings, for example. The offence also only applies if a carriage service is used, and thus it fails to consider situations where private sexual material may be distributed in other ways. Nevertheless, a positive of the Commonwealth offence is that it specifically has a provision targeting those who possess, control, produce, supply, or obtain private sexual material through a carriage service for commercial purposes or for the purpose of obtaining a benefit. Therefore, it specifically targets pornography rings or revenge porn websites that make a monetary profit from this criminal behaviour. In conclusion, I think it would be fair to say that revenge pornography or the non-consensual sharing of intimate images is not adequately addressed by the law in Australia, both at a federal and a state level. Hopefully the Commonwealth and New South Wales governments finally bite the bullet and introduce these new criminal offences that will specifically address this as extremely troubling criminal behaviour. Well, that's all for today, folks. Hope you enjoyed this vlog, and don't forget to subscribe to my YouTube channel below.